Yeah, the session started. With your permission, Devinder sir and me. Neeraj sir, am I audible to you?
Yes, yes.
Devinder sir, am I audible to you? So your voice is not coming. Please unmute yourself. So may I start the session?
Please start.
Yes, sir. So welcome everyone to the second Adhivakta Parishad Moot Court competition organized by the Delhi High Court unit of the Adhivakta Parishad. Here we have among with us the two judges who are very well renowned in the profession of criminal law, practicing in Delhi. First, I will introduce you with the Mr. Neeraj Shrotriya. He started his practice in the year 1989. Mainly, he works at Patiala House Court and handles other litigation work at Delhi High Court. He's a very renowned jurist. Sir was also the president of Adhivakta Parishad Patiala House Court unit, if I'm right. Yes, sir.
Yes, please.
The second judge among us is with us is Mr. Devendra Panchal. Sir started his practice in the just a minute. In the year 1992. Sir also handles mainly criminal matters. He has his chamber at Saket Court. Sir was born on 30th December 1996. And he is also the standing counsel for the Union of India at Delhi High Court. Sir mainly handles POCSO at Arms Act cases. The students who are part of today's competition, it is going to be a very enlightening experience for all of you to have both the gentlemen, both the judges with us. So with your permission, sir, may we start today's proceedings?
Excuse me, sir. I have a doubt. Actually, the other team, only first speaker is here, and the second speaker and the researcher are not present in the meeting.
Sir, she is joining. There is some network error. She will join in just 2 minutes.
Just switch on, all of you, please switch on your camera. Yeah, what's the issue?
So there was a network error. She is joining.
If someone is joined. So first of all, can you just let me know the time division you have?
Yes, sir. The prosecution
Seven.
will be taking 13 minutes for the first speaker and 14 minutes for the second speaker, and we will be reserving 3 minutes for the rejoinders.
Please switch on your camera. 538 you are saying, right? Yeah.
Yes, my camera is switched on. Am I
Yeah.
visible?
No. Now you're visible. Say.
Sir, 13 minutes for the first council and 14 minutes for the second council, and 3 minutes for the rejoinder. 13 for the first, 14
So
for the second, and 3 minutes for the rejoinder. Sir, one is 13 minutes,
23.
second is 14 minutes, and 3 minutes for the rejoinder. Am I
13,
clear, sir?
14, and 3. Okay.
Yes. Thank you, sir.
And 5 and 7.
Council 1 and Council 2 go for 15 minutes each.
No time for rebuttal.
No.
Are you sure?
15 minutes for Council 1 and 14 minutes for Council 2 and 1 minute rebuttal.
1 minute rebuttal. Okay.
Thank you.
Yes, sir, can we start? Devendra sir, can we start today's proceedings? Yeah. Team 538, you can start proceedings.
The council seeks permission to address the bench collectively as the lordships.
Please carry on.
Much obliged, Your Lordship. The council is here in front of this court on behalf of state in the case of state NIA versus Samir and others, where the accused are apprehended to have done an offense under section 120B, 121, 123, 489B, 489C, and 201 of the Indian Penal Code 1860, and sections 16, 17, 18, and 20 of the Unlawful Activities Prevention Act 1967. The accused in this case were caught carrying FICN for bomb blast in Pulwama on an army convoy. The case is filed before this honorable court under section 13 and 14 of the National Investigation Agency Act 2008 in order to take cognizance in this matter. The trial court is entitled to decide the matter under section 11 and 12 of the NIA Act as decided also in the case of Bikramjit Singh versus State of Punjab. Your lordships may refer to page 5 of the memorial submitted by the prosecution. The council seeks permission to address the facts.
Please.
Your Lordship, based on the secret information received by the police station special cell of Delhi Police, Lodhi Road, two persons, namely Samir and Monu, were arrested from Old Delhi Railway Station on 25th February. FICN, that is forged Indian currency notes amounting to rupees 5 lakhs, each were recovered from the two accused from the shoulder bags. They revealed that they received the FICN from Kallu. Special cell registered the FIR and commenced the investigation. The notes were then sent to CFSL and the preliminary report revealed that the notes were of high quality fake Indian currency. The case was then transferred to the NIA. On investigation by NIA, Samir and Monu revealed that the notes were to be used for the bomb blast at an army convoy in Pulwama. They also revealed about the role of Peter, who helped them in obtaining the FICN, and Sohail, who was the mastermind and was in touch with Lashkar-e-Taiba. Even the call detail reports also show that they all had nexus with each other as they were in constant contact with each other. Peter died due to committing suicide on 22nd June 2015. The NIA found an independent witness, Shah Rukh Khan, who saw Kallu with some unknown person. Kallu didn't reveal anything about Sohail. CDR analysis established the presence of Samir, Monu, and Kallu in West Bengal. And at the last charge sheet was submitted in this honorable court on 24th August 2015. Now, the council would seek the permission of a lordship to move towards the issues.
Please.
Lordship, I will be dealing with the first two issues. That is, does the act of the accused amounts to an offense under section 489B and 489C of the Indian Penal Code 1860? And does the act of the accused person qualifies as a terrorist act under section 16 and 17 of the UAPA 1967? Beginning with the first issue, the council would like to tell the court that the currency that was being carried by the accused is FICN and is also covered under the definition of counterfeit under section 28 of the Indian Penal Code, as the notes resemble actual currency notes and the accused, knowing it to be likely that deception will thereby be practiced, trafficked, or smuggled the FICN from West Bengal to Delhi. The forged nature of the notes is sufficiently proved by the CFSL reports on 16th April and 23rd May. Your lordships may refer to point 1.2 on page number 11 of the memorial. Now, in order to establish the offense under section 489B and 489C, the council seeks to attract the attention of your lordships towards the words buying or receiving from any other person or otherwise trafficking. According to the disclosures and admissions made by Kallu in point 17.31 of the charge sheet, he recovered the he bought the FICN for rupees 3.5 lakh, which was amounting to rupees 10 lakh, and hence was covered under the buying of FICN. Now, for the first two accused, Samir and Monu, they were trafficking the FICN from West Bengal to Delhi. We can infer from the case of Zubeda Chitrakar versus State of West Bengal. Your lordships may refer to point 1.3.2 on page number 12 of the memorial. It was mentioned that in order to constitute a case under section 489B, active transportation amounts to trafficking. And when the possession is of sizable quantity, it can be considered as active possession, according to the case of Rayab Jusab Sama versus State of Gujarat. Your lordships may refer to point 1.3.3 of on page number 12 of the memorial. So the possession of FICN is not dormant in the present case because the amount of FICN was rupees 10 lakh. Again, in the case of Shabir Sheikh versus State of Madhya Pradesh, the court again held that carrying a sizable quantity of fake currency in a concealed manner would amount to active transportation. Hence, the carrying of FICN of sizable quantity amounting to rupees 10 lakh would amount to trafficking of notes. Now, coming on to the most important part in order to prove this offense is the presence of mens rea or intent. It is mentioned in section 489B that the person knowingly that the FICN was forged, and without this mens rea, this offense cannot be proved. In the case of Muhammad Shaukat Ali versus State of West Bengal, your lordships may refer to point 1.4.2 on page number 13 of the memorial. The mens rea was duly established, and to quote the judgment, having found that the recovery was effected from inside the underwear of the accused and that the recovered material were fake Indian currency notes, the court below is justified in imputing the accused with knowledge about the nature of such incriminating material as being fake currency notes. The fact that in the present case also the recovery was from a secret cavity of the bags carried by the accused. Therefore, mens rea is duly established as the intention of both the parties in the cases was to conceal and hide such money and traffic it to a place where it was intended to be in order to help in executing the bomb blast. Also, in the case of Khurshid Ahmed versus State of West Bengal, your lordships may refer to point 1.4.4 on page number 13 of the memorial. The court gave out an interpretation that where the accused could not justify his possession of FICN, the mens rea will stand established. And here also the accused could not in any way justify the possession of FICN, so mens rea can be established. No explanation is provided by the accused so as to establish a reasonable doubt that the possession of FICN with them was not intentional. There was no break in the chain of custody between the seizure of currency notes and its examination by the expert. According to Section 106 of the Evidence Act, the burden to prove his innocence was upon him, and they didn't prove any such material so as to prove their innocence. Their failure to do so raises an adverse inference against them, and for such inference, we could conclude that their possession was not mere conscious possession. They were either meant to use the counterfeit currency notes or transport them from West Bengal to Delhi. Hence, the essentials to establish the offense under this section are established and hence proved beyond reasonable doubt. So, all the three accused are liable under this section and should be provided adequate punishment that the court thinks fit. Now, coming on to the second issue, that is, does the act of the accused qualifies as a terrorist act under section 16 and 17 of the UAPA? Section 16 mentions the punishment for terrorist act. The council contends that the act itself is not a terrorist act and is covered in under definition of terrorist act, which is mentioned in section 15 of UAPA. On the bare reading of the section, the following essentials can be established in order to prove the offense under this section. The essentials are, first of all, intent. Second, use of bombs, dynamites, or other explosive substance or inflammable substances or firearms or other lethal weapons or poisonous or noxious gases, etc. And the third is threatening the unity, integrity, security, economic security, or sovereignty of India. The intent that is mentioned in this section needs to be interpreted in the widest way possible, as a narrow interpretation may lead to the acquittal of the culprits, which may be harmful to the public at large in future. Presence of the intent of the accused can be proved by the statements made by Monu in point 17.11, page number 17 of the proposition. Here, Monu disclosed the role of Kallu and Peter in the sale and purchase of FICN. He also said that they received instructions from Kallu to go to Pulwama after reaching Delhi and deliver those notes to Peter. Also, he revealed that Kallu was doing the main planning. The statement is thus covered under Section 27 of the Indian Evidence Act, as the statements made by Monu led to the discovery of the new accused Kallu and Peter, and Kallu was subsequently found and arrested, and Peter committed suicide on 23rd June. Also, again in point 17.27, your lordships may refer to page 22 of the proposition. Based on the disclosures, sketches were prepared, locations were pointed out, the places where he took both Samir Monu from Malda Town railway station and sent them to his house through one youth of nearby village. He also pointed out his own house where the delivery of FICN of denomination rupees 10 lakh took place in presence of Sohail. These facts establish that all the accused had the intent to cause disruption of unity, integrity, security, economic security, and sovereignty of India. Hence, they are covered in the Terrorist Act under Section 15, subsection A, subsection 3A. Also, to establish the mens rea, that is the intent, it is added that the accused had the same intent, that is to shoot the country by a bomb attack on the Indian Army convoy, for which these notes were required. In Exhibit 7, your lordships may refer to page 54 and 55 of the proposition. The accused said that they were mad at the government. They even exclaimed that they got a clear vision of the government's hidden agenda behind the imposing sanctions on poor class. Also, the government wanted to divide youths in different religions and castes. All these statements can simply be interpreted that they were willing to do something against the government, which they actually did as soon as they got a chance. Also, they were working upon raising funds, the same funds which were used by Kallu to buy the FICN. All the facts add up to establish mens rea under section 15. In the case of Ridal Hussain Khan versus National Investigation Agency, the lordships may refer to point 2.2.5 on page number 18. It was established that the articles such as bomb, firearm, etc. ought to have been used in such a manner which causes or is likely to cause death or injury to any person or loss or damage. This means that the bombs and firearms only need ought to be used in order to affect the monetary stability of country by the action of trafficking of high quality FICM. There is no need that the arms or substances should actually be used. Again, in the same case, it is mentioned that if the materials collected during investigation would justify at this stage a prima facie inference that the offense of terrorist act as defined by section 15 had been committed, then the person or persons concerned would be punishable under section 16 of UAP Act. There is enough prima facie evidence in order to prove offense under section 15 and the accused are liable for punishment under section 16 of UAPA. Section 16 can be interpreted that any person who has committed a terrorist act shall in any other case be liable to punishment. Here the phrase in any other case means that the cases where there is no actual death of a person, but any other case. This also includes the offense in the present case also. The last point of my contention is that the accused are also booked for offense under section 17 of the UAP, which mentions the punishment for raising funds for terrorist act. From the bare reading of the section, the following essentials can be established in order to prove the offense. The essentials are raising or providing collecting funds from or to any person, knowledge that the funds are likely to be used for terrorist act, and notwithstanding whether such funds were actually used or not for the commission of such act. For the first essential, Kallu is covered under the word providing, as he provided FICN to Samir and Monu. Also, Samir and Monu have collected the funds from Kallu, so they are also liable under the first essential. That according to the second essential, intent is to be proved that the accused have knowingly that the funds are likely to be used by a person who is connected to a terrorist organization have trafficked such funds. It is duly established that Suhail was connected to Lashkar-e-Taiba, which is a terrorist organization according to the first schedule of UAPA. And since Samir and Kallu had knowledge that Suhail had so connections and they smuggled the FICN from West Bengal to Delhi, they all are liable. The third essential is that it does not matter whether such notes were actually used or not, which establishes the offense of the accused under this section. It is mentioned in the explanation provided to section that raising funds.
I think your time is over.
Lordship, I will take 1 minute to summarize. I will say 1 minute to summarize.
Please extend some time.
Yes, Lordship.
How much you want? How much you want?
Just 1 minute or 30 seconds, just enough. Much obliged, Lordship. The third essential is that it does not matter whether such notes were actually used or not, which established the offense of the accused under this section. It is mentioned in the explanation provided in the section that raising funds shall include raising or collecting or providing funds through production or smuggling of circulation of high quality counterfeit Indian currency, which is clearly the case in the present situation also. Also, in the explanation, it is mentioned that raising or collecting or providing of funds in any manner for the benefit of or to an individual terrorist gang or terrorist organization for the purpose not specifically covered under section 15 shall also be construed as an offense. According to this explanation, even if the collecting or raising of funds is not specifically covered under section 15, even then this section will apply against the accused. So now all the essentials that need to be proved for the section 489B, 489C, section 15, 16 and 17 of the UAPA and 489B and 489C of the Indian Penal Code are established beyond reasonable doubt, and the accused should be liable to punishment as the court thinks fit. Now I would like to offer the podium to my co-counsel to continue with the further issues.
Okay, carry on.
Sir, can I start?
Yeah, please.
First, the council would like to seek the permission of this honorable bench to refer to it as your lordships.
Please. Yeah.
Much obliged, your lordship. As my co-counsel has already referred to the first and second issue, the council would like to address to the third and the fourth issue. The third issue being that if the accused Samir, Monu, and Kalu alias Mama are liable under section 120B Indian Penal Code and section 18 and 20 of the Unlawful Activities Prevention Act, And the fourth issue being that if the accused, namely Samir, Monu, and Kalu alias Mama, are liable under Section 201, 121, and 123 of the Indian Penal Code 1860. Now the council would like to seek the permission of this honorable bench to start with the third issue.
Please carry.
Much obliged, Your Lordship. Here, first referring to the point to the offences committed by the accused that are punishable under Section 120B of the Indian Penal Code and Section 18 of the Unlawful Activities Prevention Act. All the three accused, along with Suhail and Peter, were conspiring to execute a bomb blast on the Indian Army convoy in Pulwama on 15th of August 2015. The facts are also disclosed by my co-counsel, and the accused himself disclosed this fact in the charge sheet that is submitted before this honorable court. While all this was done on the instructions of Suhail, which is said to be the main conspirator of the whole plan, and was in complete touch with Lashkar-e-Taiba in Pakistan and Bangladesh. For this, please refer to para 17.5, 17.14, and 17.15 in the Moot proposition, which refers to the charge sheet, and most importantly to para 17.32 and 17.33 of the charge sheet, which is on the page 15 of the Moot proposition, as all this reveals the planning they made. It is pertinent to mention here that while the statement of the witness PW2 Iqbal Khan, as mentioned on page 48 of the Moot proposition, as well as their contact list in the mobile phone seized, clearly establishes their association, the tower locations of the mobile phones, their call records, and the transcripts on important dates establishes their plan relating to the bomb blast, and hence well support the facts disclosed by the accused. For this, please refer to 17.36 para of the charge sheet, which is on page 25 of the Moot proposition, which refers to the technical evidences that are present in the present case. Moving further, the council would like to draw the attention of this honorable court to the fact that all the ingredients are satisfied in the present case that must be proved in order to establish the criminal conspiracy under section 120A IPC, as well as elaborated by the Honorable Supreme Court of India in the case of Yogesh versus State of Maharashtra 2008. As also stated in the memorial submitted before this court, please refer to page 22, para 3.1.3. That is, there are two or more persons, there was agreement between them, and most importantly, the agreement was done to do or caused to do an illegal act or any legal act by any illegal means. As here, the accused were planning not only in the trafficking of the fake Indian currency notes, but also the fact that they were to be used in the execution of a bomb blast clears their agreement to do any illegal act. In the same judgment, it was also observed, as please refer to page 25, para 3.1.14 of the memorial, as I can summarize these ingredients, that the meeting of the minds of the person is a sine qua non of the criminal conspiracy, and also that it is hatched in secrecy, and hence there is no direct proof to it. So this can be inferred from the circumstances that are proved by the prosecution, if such inference is possible, as in this case it is. Also, when the section 120A of the IPC is read along with section 34 IPC, which talks about the acts done by several persons in furtherance of common intention, that is the meeting of the minds, and also read along with section 10 of the Indian Evidence Act, which provides the grounds that are to be established by the prosecution in order to prove the charge of the conspiracy against the accused, which clearly says that the circumstantial evidences are sufficient to prove the charge of criminal conspiracy against the accused. As in the present case, the CDR reports, the tower locations, the transcripts of their calls, as well as the witnesses clearly and the prime facie proves that the fact that all the accused, namely Samir, Monu, and Kalu alias Mama, along with Peter and Sohail, have committed the offense of criminal conspiracy and hence will be liable under section 120B of the IPC. As this was done to execute a terrorist act, it will also constitute the offense under section 18 of the UAPA Act. Moving further to the second point under this issue, that is if the accused are liable under section 20, 38, and 39 of the UAPA Act. As per the statement given under section 161 CRPC by the accused, as well as the facts disclosed in the charge sheet by them, as to summarize, that Samir, Monu, and Kalu alias Mama, along with Peter and Sohail, were part of an organization which is known to be as a youth union, and they were all working in that organization and spreading awareness about its campaigns and raising funds for it, which they have even started receiving from Pakistan and Bangladesh. Kalu alias Mama stated that the organization was working against the policies of the government, and that is the point to be noted, that they were working against the government. Thereby taking cover as a union to speak for the other rights, as a terrorist unit was working, involved in conspiracy against the accused, in order to infringe the peace and harmony in the society and to wage war against them. As in this case, is the bomb blast that is going to be conducted on the Indian Army convoy and is a serious offense. And it's not the first time they have done it, but they have done it in many instances and they have on their own disclosed the fact that is supported by the CDRs and the transcripts too. Please refer to para 17.10 on page 17 as well as 17.5 of page 21 of the Moot proposition. Most importantly to 17.29 in which the Kalu himself disclosed this fact and earlier Sameer and Monu disclosed the same facts. PW2 Iqbal Khan stated, as mentioned on page 48 of the Moot proposition, that they were once even detained because of that, because Kalu made some brilliant remarks like India not being a country worth living and Dulhan ko sajana padega in a Larry as a secret code that is organized by the organization. Therefore, it has been stated that the government had put many sanctions on the working of that organization due to these facts. Even Kalu alias Mama, in a statement under Section 101 C of Ipc, admitted that the FIR was lodged against Sohail for the same. PW3 Rupendra Singh, who is the superintendent of police, also mentioned the fact that during the time of the investigation, it was revealed that Sohail was the main conspirator and was doing all the plan on the instructions of Lashkar and Taiba as he was in direct contact with them, as also admitted by all the accused persons. Please refer to para 17.29 of the Moot proposition as it summarizes everything. Firstly, now coming to the point that whether the youth union, the organization the accused were a part of, was a terrorist organization or a terrorist gang. It was a terrorist gang under Section 2, subsection 1 of the UAPA Act, as they were involved in a terrorist act. And also they would come under the ambit of a terrorist organization. How? Because it is well-established fact that the organization the accused were a part of is working under the instructions and directions of Lashkar and Taiba, which is the fifth item mentioned in the list of banned terrorist organization under Section 35 of the Unlawful Activities Prevention Act, and this was released by the Ministry of Home Affairs Central Government. This says, as per Section 2, subsection 1, clause M of M, the youth union will be a terrorist organization. Now, as it was recently observed in September 2021, in the case of Thwasa Fazal versus Union of India, the intent to further the activities under these sections relating to a terrorist organization is mandatory to make out an offense under Section 38 and 39 of the UAPA. And in the present case, the circumstantial evidences are sufficient, as also said by my co-counsel, and the counsellor also stated that the facts clearly shows their association and the fact that they were involved with the organization, they associate themselves with the organization. They also helps to profess it to various rallies they organize and even were raising funds for the same. Everything under this section proves that they would be liable under Section 38 and 39 of the UAPA Act, and hence their actions are punishable under Section 20 of the UAPA Act. Now the council would like to seek the permission of this honorable court to raise the fourth issue. Much obliged, your lordship. Coming to the first point, that if the accused persons are liable under Section 201 of the Indian Penal Code 1860. Now, the point to be noticed that the main ingredients of establishing an offense under Section 201 of the Indian Penal Code was observed in the landmark case of V.L. Teresa versus State of Kerala, in which are totally satisfied in the present case, and the council will prove the same. Please refer to para 4.1.3 of the memorial to see the ingredients. The council has already proven that all the accused, namely Sameer and Monu and Kalu alias Mama, are liable under Section 489B, 489C, and Section 16, 17, 18, and 20 of the UAPA Act. Also, it has been established by the council that they not only had the knowledge of happening of the said offense, but they intentionally participated in the commission of the said offense and even encouraged the same, which establishes their mens rea too, hence fulfilling the first and the second ingredient under this section, that is, the commission of an offense and the knowledge and the reason to believe its commission. Moving further, according to the charge sheet that is submitted before this honorable court, it is mentioned that no incriminating substance was recovered from the house of Sohail, which was done a number of times during the investigation. Please refer to para 17.28 of the Moot proposition, which says the same. And it was there mentioned that the fact that the accused Kalu has destroyed all the evidences, the technical evidences, the CDR, the mobile location, as well as the statement given by the accused, that would be admissible under Section 27 of the Indian Evidence Act, clearly establishes the contact between Kalu and Sohail. And not only this, also the fact that the independent witnesses named Shah Rukh Khan, who claimed that he had sent Heen Sohail on 20th of June 2015 in Kalichak village, Malda, with two persons, from which one was Kalu, and it was the date in which on which the Sohail absconded India and ran to Bangladesh. And it clearly shows the fact that hence Kalu has helped the Sohail in absconding, as well as the fact that he had helped him in the disappearance of evidences in his house. Also, moving further, as mentioned in the chart sheet, please refer to para 17.30 and 17.31, that is on the page 23 of the Moot proposition. The accused admitted the fact that initially the deal was to be materialized in the first week of the FAB, but the deal couldn't materialize because Samir and Monu were asked to return back. Why is that so? Because Iqbal Khan, a friend of theirs, was arrested by the local police in case of suspicion on 5th of February 2015, and they were fearing more arrests, so they went underground. And in this fact, they have helped and they have done the disappearance of evidence in this case. It also is established by the CTR and the transcripts as he made a telephonic contact with Monu, duly established by the CDR of their mobile numbers too. Because of this fact, the accused disappeared the evidences and given false information under section 161, as Samir and Monu have said that they had no intention and they were not known of the fact that they had the fake notes in their bags. And my co-counsel has already proved the fact that they had the intention, and the mens rea is being proved. It is from these circumstantial evidences, with no loose ends, it is hereby proved that not only did Kalu alias Mama, Samir and Monu were involved in disappearing of evidences and the house of Sohail and at other places, but also the fact that Kalu alias Mama helped Sohail in escaping the Bangladesh. Hence, all the facts fulfills the third ingredient as well as the fourth ingredient, that is, they have caused the disappearance of evidence and have given the false information, and they have done with the aim to screen the offender. And it also fulfills the fifth ingredient, as it has a cogent evidences and nothing is there which is alleged on the basis of suspicion. Hence, all the ingredients are fully satisfied in the present case, making them liable under section 201 IPC. Now, moving further, that whether the act of the accused persons amount to waging of war under section 121 and 123 of the Indian Penal Code 1860. It is well established by the prosecution that all the accused, namely Samir, Monu, and Kalu alias Mama, along with Peter and Sohail, were a part of a terrorist organization, and hence they are liable under Section 20 of the UAPA Act. And also, they were attempting for a bomb blast attack on the Indian Army convoy in Pulwama on 15th of August 2015, making them liable under Section 16, 17, and 18 of the UAPA Act too. A bomb blast attack on the Indian Army unit would likely to take a great toll on the security of the country, as it would disrupt the economic, social, political situations of the country to a large extent. And if you look at the bigger picture, it directly aimed towards disrupting the peace and harmony of the country.
Time is over, Ms. Speaker.
Sir, I just received that 1 minute is left. I just received it.
Yeah, but the time is over. You may seek permission from the judges.
May I have
If they allow you, then only you can
for
speak
just
further.
1 minute more? So
Try
I
to
can
finish.
summarize.
Try to finish it within 1 minute.
Yes, sir, I can finish it in 1 minute.
Please
Thank you, sir.
grant him.
The organization that the accused were a part of is directly in contact with Lashkar and Taiba. It is also well established, and they were involved in spreading the same message of hatred among the masses, and also they were detained as revealed by the PW2 witness Iqbal Khan. The CDR reports and the mobile location confirmed the same, and the FIR was also lodged for the same against the Sohail. It reveals the abetment of waging of war, and the fact that they were going to be execute a bomb blast on the Indian Army convoy in Pulwama refers to the fact that they were attempting to wage war against the government of India, hence making them liable under Section 121 IPC. Also, it is well established of the fact that they were all doing in secrecy, the conspiracy and everything, because they were even using the secret codes like Dulan ko sajana padega. And also they are liable under Section 201 IPC because they were involved in the disappearance of evidence. This proves that they were planning in secrecy a plan to wage war against the government of India, hence making them liable under Section 123 of the IPC. Here the council rests with its arguments. Coming to the prayer, the council would like to pray to this honorable court that the accused are guilty and should be held liable under Section 120B, 489B, 489C, 121, 123, and 201 of the Indian Penal Code 1860, and also under Section 16, 17, 18, and 20 of the Unlawful Activities Prevention Act. Hence, set an example before everyone not to try this again against the government of India to infringe the peace and harmony in the country. The council rests here.
Okay.
Thank you, sir.
Excuse me, sir. I have a question. I just got a message that my camera is off, but my camera has been on the whole time.
Actually, your video was not visible. That's why I messaged you.
Okay, sir, but my camera.
But
is
now
on.
you are visible.
My camera is constantly on during the whole round also.
Okay.
Yes, sir. Everyone was visible.
Maybe there was some network
To me,
issue on
he
your
was
side.
not visible.
No, actually, he was visible.
Okay. Sir.
Maybe there was some network issue.
There is
What
a
is in your
query.
code, sir?
There is a query from Team 1. Both of you can answer. What do you say about the arrest memo and personal search memo? That both are not signed by the accused.
Sir, the personal search memo and the arrest memo are being signed by the independent witness that were present there. So
Okay.
it qualifies as
If
a
anything
valid
you want to
document.
say, then it's okay. If you want to take any help from that, then tell me. Otherwise, that is on record.
Lordship, I can get a question.
So, personal search memo, both are not signed.
Okay. But
The
Lordship,
accused,
they are signed
by
by
the
the
accused,
independent witnesses. They're signed by
Yes, sir.
by the accused persons.
Okay, Your Lordship.
Do you want to say anything?
No, Your Lordship.
Okay. I think team second may start it.
Sir, with your permission, can we move on to the next speaker?
Yeah, please.
Different side.
Please
So-
start.
Good morning, Honorable Justice.
Team
Good morning.
517.
Good morning, Honorable Justice. We are here by the Council of
So you
Respondent
are
as
going
Speaker 1 and
to
Speaker.
take 15 minutes, right? Speaker 1.
Yes.
For the respondent, you are going to take 15 minutes time.
Yes.
Speaker 1.
Yeah.
Yeah. Continue.
Honorable Bench, the respondent submits to the jurisdiction of Honorable Court of New Delhi, Patiala House Court under Section 24, 25, 26 of Indian Evidence Act, Section 54 and 167 of CRPC, and Article 20, Clause 3 of Indian Constitution, by virtue of this court has power to entertain against plaintiff. Honorable Justice, the counsel from respondent side would like to raise arguments.
Please carry on.
Much obliged. My first argument is illegal detention of Samir and others with according to Section 167 of CRPC. Section 167 of CRPC says procedure when investigation cannot be completed in 24 hours. Whenever any person is arrested and detained in custody and it appears that the investigation cannot be completed within the period of 24 hours fixed by Section 57, and there are grounds for believing that the accusation or information is well founded, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transfer to the nearest judicial magistrate a copy of the entries and the diary hereinafter prescribing related to the case, and shall at the same time forward the accused to such magistrate. The magistrate to whom an accused person is forwarded under this section may, whether he has or has no jurisdiction to try the case, from time to time authorize the detention of the accused in such custody as such magistrate thinks fit, for a term not exceeding 15 days in the whole. And if he has no jurisdiction to try the case or commit it for trial and consider further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction, provided that the magistrate may authorize the detention of the accused person otherwise than in the custody of the police beyond the period of 15 days, if he is satisfied that adequate grounds exist for doing so. But no magistrate shall, authorize the detention of the accused person in custody under this paragraph for a total period exceeding 90 days, with the investigation relates to an offence punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years, and 60 days with the investigation relates to any other offence. And on the expiry of the said period of 90 days or 60 days, as the case may be, the accused shall be released on bail if he is prepared to and does furnish bail. And every person released on bail under this section shall be deemed to be so released under the provisions of Chapter 33 for the purpose of that chapter. Section 167 of CRPC says that any person is arrested and detained in custody. An investigation cannot be completed within 24 hours, and if there are well-grounded reasons that there is necessity for further extension of investigation period, the magistrate may authorize the detention of the accused according to the proviso of Section 167 of CRPC for a total period of exceeding 90 days, when the investigation relates to an offence punishable with death, for life, or for a term not less than 10 years, or 60 days, where investigation relates to any other offence. Under the stated case, Smith and others have been arrested and detained in custody for offence of whose imprisonment is not less than 10 years. So, according to the proviso clause of Section 167 of CRPC, with order of the magistrate, they can legally detain maximum for the period of 90 days. And if he fails to complete investigation within the 90 days, they shall be released on bail, on default bail, and they have right to furnish bail. According to the facts, Smith and others have been detained for more than maximum period, that is 90 days. They have been arrested on 25 to 2015 at platform number 5 of Old Delhi railway station, and charge sheet has been presented under section 173 clause 2 to the competent magistrate on 24/8/2015. So their detention is illegal with accordance to section 167 of CRPC, and they have right to furnish bail. I would like to reference my case law, Sanjay Dutt versus State through CBI Bombay. Honorable Court held that creates an indefeasible right in an accused person on account of the default by the investigation agency and the completion of the investigation with the maximum period or extended as the case may be to seek an order for his release on bail. The counsel would like to raise second argument. Admission regarding involvement of Smear and Monu during interrogation and not admissible under court. As in accordance to above case, the admission given by Samir and Monu during interrogation regarding involvement in the sale and purchase of FSCN notes. The statement given by Samir and Monu against police officers are not admissible under Section 24, 25, and 26 of Indian Evidence Act and are not conclusive evidence. These sections, that is Section 24, 25, and 26 of CRPC, deals with extrajudicial confessions. Section 24 of Indian Evidence Act. Confession caused by inducement, threat, or promise when irrelevant in criminal proceedings. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by an inducement, threat, having reference to the charge against the accused person. Section 24 of the Indian Evidence Act make a confession as irrelevant if the court feels that it had been made in coerced circumstances or as a result of threat and inducement. The principle upon which this is the said that a confession made by a person under the guise of a threat or a promise will not be taken as a valid testimony. I would like to enlighten some ingredients of Section 24. First, the confession came into effect due to inducement, threat, or promise. Confession made by force or violence are not free and voluntary, and such confessions are not admissible. The court has a responsibility to determine whether or not it is voluntary to make a confession. Interference with non-voluntary existence may be suggested by religion itself or by evidence of the prosecution or by evidence provided by the accused individual or by circumstances concerning them, which the court shall take into account. If the court determines that the confession has been improperly obtained, it should be rejected. The inducement, threat, or promise relates to the charge in question. The fee in question must include rewards, warning, or commitments, etc. The defendant must have been coerced by the person in charge to make a confessional statement. If an accused person is accused of any crime and is told that if he acknowledges the truth in the present case, the commitment is not linked to the present case, so the confession is true. Scope of Section 24. Section 24 of the Indian Evidence Act prohibits all faiths. This notes that if a confession seems to have come about a result of the threat by any person in authority, promise, or incitement, this is meaningless and cannot be proved against any accused. Although, in section 24 to 30, the substantive law of the faith has been created. The basic rule of law is that confession is admissible only if it is voluntary. These will not be admissible if they are not deemed voluntary. In a case law, Hiramba Brahma versus State of Assam, it was held that all the confessional statements made to the police or any other law enforcement officers qualifies as extrajudicial confessions. Section 25 of Indian Evidence Act, confession to police officers not to be proved. No confession made to a police officer shall be proved as against a person accused of any offence. Section 25 of Indian Evidence Act provides that any confession made to a police officer will not be admissible in court. The intent of the legislature in formulating this section was to put an end to all the malpractices used by police officers for extracting evidence. This section says that the confession given to a police officer is not admissible. It can also be not proved because the object of this section is to prevent the practices of torture made by police officers to an accused so that they cannot force him or her to give a false confession. If the confession is made in front of any other person, it will be relevant only if the police officer is present at that moment. This particular section applies to a confessional statement only if they are made orally or in the form of FIR presented by an accused. In a case law, Ram Singh versus Central Bureau of Narcotics held that Section 25 make confessional statement of accused before police officer is inadmissible is evidence which cannot be brought on record by prosecution to obtain conviction. Section 26 of Indian Evidence Act. Confession by accused while in custody of police not to be proved against him. No confession made by any person while he is in the custody of a police officer, unless it is made in the immediate presence of a magistrate, shall be proved as against such person. Section 26 of Indian Evidence Act provides that confession made while in the custody of police officer will be held as invalid unless they are made in the immediate presence of a magistrate. This section entails those situations where the confession is made by the accused to someone else other than police officer but under the custody of police. This section states that no confession of a person in police custody is provable. It applies in the context that the false confession could be extracted in through fear or torture. It not applies to confession to a policeman but to any other person. The only exception to this rule is that the confession is made by an accused in front of magistrate. It will be admissible. In a case law, Seher versus State of Karnataka, statement made in police custody are considered to be unreliable unless they have been subjected to cross-examination. So, here we can conclude that any confession made by Samir and Monu is not admissible in the court, and those statements cannot be made liable for the offence because it may be presumed that the confession may be made by them under threat, coercion of police. On with justice, I would like to raise third argument. No medical examination has been done of arrested person according to section 54 of CRPC. As according to section 54 of CRPC, there shall be medical examination of arrested person. Section 54 of CRPC says examination of arrested person by medical officer. When any person is arrested, he shall be examined by a medical officer in the service of a central or state government, and in case the medical officer is not available, by a registered medical practitioner soon after the arrest is made. The medical officer or a registered medical practitioner so examining the arrested person shall prepare the record of such examination, mentioning therein any injuries or mark of violence upon the person arrested, and the approximate time when such injuries or marks may be inflicted. Where an examination is made under subsection 1, a copy of the report of such examination shall be furnished by the medical officer or registered medical practitioner as the case may be, to the arrested person or the person nominated by such person. Here, in the above case, there is no exhibit attached of medical examination in police report, so it can be presumed that confession recorded by them can be made through threat, force, and coercion, and so Samir and others cannot be charged under these sections that are charged in police report. In a case law, Sheila Barse versus State of Maharashtra, in a case where accused does not make any prayer, it is the duty of the magistrate to inform the arrested person about his right to get himself medically examined in case he has complaints of physical torture or maltreatment in police custody. The non-compliance of this important provision by the magistrate has prompted the High Courts to issue such directions. In a case, Mukesh Kumar versus State, in this case, it was held that the procedure adopted by the magistrate in examining the body of the accused person himself and then dismissing the application on his observation that they were seen in normal posture was unwholly unwarranted and erroneous. Honorable Justice, the counsel of respondent would like to call co-counsel to raise issue on the basis of the facts.
Carry on.
Please.
Obliged.
Good afternoon, judges.
Good afternoon.
May it please the court if I proceed with the further arguments?
Please carry on.
Proceed.
The fourth argument raises that technical evidence shows that they have links with each other regarding project against government policies. The call detailed records in paragraph 17.16 shows that Sameer and others are in constant touch with each other. So these constant touch links between them clearly shows that they are commonly working on development program so as to aware of the fact regarding government policies and therefore cannot be oppressed by those policies. It prima facie shows that they are working on this project. Prima facie, which means at very first sight. Hence, these facts are at the very first sight that they are commonly working on the development program so as to aware of the facts regarding the policies and therefore cannot be oppressed by these policies. This shows that Sameer and others were not involved in any kind of terrorist attacks. Rather, they were involved in project against government policies so as to aware the oppressed people of the society. The fifth argument raises that Sameer and others are not liable for the possession of FICN notes. According to the charge sheet submitted by the police officer in the charge, they had been liable under section 489B and 489C of Indian Penal Code. 489B of Indian Penal Code says, using a genuine, forged or counterfeit currency notes or bank notes, whoever sells to or buys or receives from any other person or otherwise traffics in or uses as genuine any forged or counterfeit currency notes or bank notes, knowing or having reason to believe the same to be forged or counterfeit, shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. And section 489C of IPC says, possession of forged or counterfeit currency notes or bank notes. Whoever has in his possession any forged or counterfeit currency notes or bank notes, knowing or having reason to believe the same to be forged or counterfeit and intending to use the same as genuine or that it may be used as genuine, shall be punished with imprisonment for either description for a term which may extend to 7 years or with fine or with both. According to section 489B and 489C of IPC, any person having knowledge or reason to believe that they sells or lays or receives from any other person forged currency or reason to believe that they have possession of forged currencies. But as per statement given under section 161 of CRPC, Sameer and Monu are not having any knowledge or and aware of having forged currency in their possession while traveling to Malada town. And also, as per statement given by all others, that they are working on development programs to aware oppressed people of society against government policies, for which all the members were raising funds. And while raising funds, they were funded by many volunteers, including foreign countries such as Bangladesh and Pakistan. So, Kalu Mama, who was having actual possession of the forged currency before handing over to Sameer and Monu, that was came into his possession through volunteers and clarifies that they were not aware regarding forged currency notes. And also, Kalu Mama in his statement reveals that Sohail got information that someone is trying to disrupt the development program, and it shows that there must be conspiracy against Sameer and others to libel them under section 489B and 489C of Indian Penal Code, so as their development program could not be flourished. Hence, we can conclude that 489B and 489C of Indian Penal Code mainly deals with mens rea, that is bad intention, to apply or libel any person under Section 489B and 489C. There, there should be bad intention and circumstances of the case clearly shows that they are innocent and having no malified intention. So they should not be liable under this section. As mentioned in case Pinto Jha versus State of UP, it has been submitted that from the side of the applicant that he is innocent and has committed no offence, that he has been falsely implicated in this case due to anonymity. It has further been submitted that keeping in view the allegation as appearing from the FIR at the most a case under section 489C of IPC which is bailable offence is made out. And in Shabir Sheikh versus State of Madhya Pradesh, holding that such cases cannot be treated as those of mere dormant possession but are of active transportation of fake currency notes which would fall within the sweep of section 49B of IPC. In the holding so, it was stated that when the accused person is found carrying seizable quantity of the fake currency notes on the public road or otherwise in concealed manner, it would amount to active transportation of such currency notes at the time when the accused person is apprehended. And Sachin and another versus State of Haryana, learned counsel of the appellant submitted only on the basis of the disposition of the two police officials, that is PW8 and PW9, the appellants could not be held guilty. He further submitted that even if the case of the prosecution is taken at its face value, then also they cannot be held guilty for various offences for retaining the fake currency notes since the prosecution has failed to show that the appellant had the requisite knowledge about the fake currency notes. He further submitted that the recovery of the computer monitor, etc., could not be proved since the prosecution has miserably failed to establish that the place where from such articles were recovered belonged to the appellant. On the strength of the above summation, he prayed for acceptance of the appeal, and Kapoor Prashant attests to the accuracy of this order acquittal of the appellant. So, Samir and others should not be made liable for possession of FICN notes under Section 489B and 489C of IPC because, according to the facts, they were working on the common object, that is, development program, for which they have also been funded from many volunteers, including foreign countries, that is Pakistan and Bangladesh. The possession of FICN notes, which Samir and others were not aware of the fact, as they all were working on the development propaganda. The council would like to raise the sixth argument.
Please carry on.
Much obliged. The sixth argument raises that Samir and others are not liable under Section 201 of IPC. Section 201 of IPC says that causing disappearance of the evidence of offence or giving false information to the screen offender. Whoever knowing or having reason to believe that an offence has been committed causes any evidence of the commission of that offence to disappear with the intention of screening the offender from legal punishment, or with that the intention gives any information respecting the offence which he knows or believes to be false. The offence should have been committed, but according to the fact or the circumstances of the case, the offence has not been committed. And also, there is no commission of the offence, and so there are no chance to disappear any evidence regarding commission of the offence or giving false information, because according to the fact, they have been arrested by the police officer at Delhi railway station before they reached to Palma to Peter, to whom they would have contacted to give the possession of FICN notes. Also, if they have any evidence, they have right to not to produce, so that the charge could not be maintained against them, and that is the right, and this right is guaranteed to them under Article 20, Clause 3 of Indian Constitution. Article 20, Clause 3 of Indian Constitution says the Indian Constitution provides immunity to an accused against self-incrimination under Article 20, Clause 3. No person accused of an offence shall be compelled to be witness against himself. It is based on the legal maxim nemo tentor podere accusare suspiam, which means no man is obliged to be a witness against himself. The Supreme Court widened the scope of this immunity by interpreting the word witness to include oral as well as documentary evidence, so that no person can be compelled to be a witness to support a prosecution against himself. This prohibition cannot be applied in cases where an object or document is searched or seized from the possession of the accused. For the same reason, the clause does not bar medical examination of the accused or obtaining the thumb impression or specimen signature from him. This immunity is available only against criminal proceedings. The Supreme Court has made it clear that in order to claim this immunity from being compelled to make himself a self-incriminating statement, it is necessary that a formal accusation must have been made against the person at the time of interrogation. He cannot claim the immunity at some general inquiry or investigation on the ground that his statement may at some later stage lead to an accusation. The compulsory administration of the narco-analysis technique amounts to testimonial compulsion and thereby triggers the protection of Article 20 Clause 3 of the Constitution. As mentioned in case MP Sharma versus Satish Chandra, it was held that the person whose name is mentioned in the first information report as accused can claim protection under Article 20 Clause 3 of the Constitution. The privilege against self-incrimination is available at both trial and pre-trial stage. That is, when the police investigation is going on and the person is regarded as an accused, or even if his name is not mentioned in the FIR as an accused. And in Nandini Satpathy versus P.L. Dhani, the appellant, a former chief minister, was called to the vigilance police station for the purpose of examination for a case filed against her under the Prevention of Corruption Act 1947. During the investigation, she was served with a long list of questions in writing which she denied to answer and claimed protection under Article 20 Clause 3. The Supreme Court held that the objective of Article 20 Clause 3 is to protect the accused from unnecessary police harassment, and the right against self-incrimination is available to witness and the accused in the same manner, and it is applicable at every stage where information is furnished. The privilege under Article 20 Clause 3 is applied at the stage of police investigation when the information is extracted. So they could not be fall under this section, and also if they do not produce any evidence, they have their fundamental right under Article 20 Clause 3 of Constitution, which says that no person can be self-incriminated against himself. Council would like to know if the bench has any questions.
I have question, but it's a common question, so I will raise it the end. Both of the teams have to answer. Team 1, would you like to say anything?
Sir, may I seek the permission of this honorable court to start with the rejoinder?
Please.
Okay, so the first thing is that the jurisdiction under which the Learned Counsel of the Defense is approaching this court is completely wrong, and it's a wrong interpretation of law. As they are approaching it under Section 25, 24, and 26 of the Indian Evidence Act, Section 54 and 167 of CRPC, and Article 20 of the Constitution of India, and they have done a complete wrong interpretation of law, as it is under Section 13 and 14 of the NIA Act, which completely defines the jurisdiction of the special courts, as also come under the UAPA cases, when rendered along with Section 11 and 12 of the NIA Act. Second point is that the Learned Counsel of Defense has presented an appeal in their memorial. An appeal is made before the higher court if the parties agree by the decision of the court, but in this case, it's the case trial is still in the final trial and the decision is not upheld yet. So unfortunately, the Learned Counsel of the Defense had longly interpreted the law as the appeal will be irrelevant at this point of time, as the judgment is not given. Third point, that the Learned Counsel of the Defense is trying, the Learned Counsel of the Defense is trying to convey by mentioning the section 167. I would like to explain it as according to the proviso clause of the section 167 of the CRPC. With order of the magistrate, they can legally detain for a maximum period of 90 days, and if fails to complete the investigation under 90 days, they shall be released on bail, and they will get a default bail, and they have to make an appeal for it. But here, in this case, the principle of finality will apply, because the appeal should be made not exceeding 180 days, should be before the charge sheet, and the case is in the final trial, the charge sheet is submitted, and the period of 180 days is also completed. So pointing out this fact of illegal detention at this point of time is completely irrelevant and a wrong interpretation of law, and they're trying to mislead the case. Also, they have no proof that there was illegal detention by the police, and they have no enmity of the police against the accused. The Learned Counsel have also the same can apply to section 50. Okay, so the next point is that the Culinary Council are opposing their own arguments, as at first they are saying that the statements are not admissible in the court, and at the next point they are basing all of their issues on the statements that are given by the accused in the charge sheet. The third point is that, as the London Council is saying, the applicability of Section 24 of the Indian Evidence Act, as it states that the confessions are taken by inducement, threat, or promise. But where is the evidence that is presented by them that the threat is given by the police? And under Section 106 of the Indian Evidence Act, the onus is on the defense to prove the
Time is over.
Sir, would
For
you
the
please
reporter.
seek the permission to give me 1 minute to
You
complete?
cannot take further time anymore.
Both
For the time.
you have taken
Enough time.
and
I
you have
think.
raised
More than 30 minutes, sir.
you have
Yes.
raised enough questions against team 2. Let them reply.
Sir, there are still
Because
two questions. If
They have
you will
only 1
permit,
minute
I would like to present them.
time. Okay, team 2.
Sir,
Thank you, sir.
on you, Neeraj, sir. Yeah.
Team 2 is
Yes,
going
team
to
517.
517. Yeah.
Yes. The council
you
from
need to
respondent
make any
side would like
rebuttal?
to raise some questions.
You are
Shall I
short.
start?
Only 1 minute to.
Yes, yes.
Okay, keep it in mind.
Okay. First point I would like to raise that there is no mens rea for two libel under section 489B and 489C. In 489B and 489C, there is completely said there should be a mens rea, that is, there should be a bad intention of having possession. And in the stated fact, Sweer and Monu and other accused having possession of FSCN notes, as their funds have been raised through the volunteers and of which Kalmama has no knowledge regarding that, and of which Sweer and Monu doesn't have knowledge that having possession of FSCN notes. Honorable Justice, also statement given by Kalu Mama under Section 161 CRPC that Sohail said him that there is some conspiracy against them. So this all had done was in order to make Sameer and others liable under this act so as to disrupt their plan. Honorable Justice, I would like to raise second point that under Section 54 of CRPC says there shall be a medical examination, and there was no medical examination exhibit attached to the FIR report, to the challan, which clearly shows that there no medical examination. It means the statement recorded under 161 of CRPC, it's like in to threat and coercion. Like 161 CRPC, like all the statements made under 161 of CRPC is made under threat coercion because there is no medical examination has been done under section 54 of CRPC. That's all. Thank you.
Okay. Now let me raise a query. I have asked from team 538 earlier, and now asking to team 517. Have you seen the memo of arrest and personal search memo? Have you seen personally?
This is a question for your personal query only, na?
Yes.
Personally, whether they would have any experience on looking the memos or not.
Yes.
But I believe that
Have you gone through that?
they are failed to. They are failed to see that memos.
I
The reason being they are students, na? So how they can come to know?
Yes. No. Yes, please.
Sir, actually, we have checked that, and we would like to answer.
Yeah,
it
please.
If you allow.
Please proceed.
Sir, according to Section 100, subsection 4 of the CRPC, only the signs of the witnesses are sufficient on the memos to comply that they are done with no enmity.
No,
No,
there
the
is
court.
one more point.
The court query was that. Court query was that whether you have seen the memos, in fact, which is used in charge sheet by the police. Have you ever seen that memos? Except definitions, you have gone.
Even in this problem.
Yes, Lordship, we have gone through the memos, and this was our contention also earlier when that the signs are there are signs of two independent witnesses already. One is an independent witness, and one is the head constable whose witness is also
Yes, sir.
valid and applicable in the present case.
Still, you have not seen. I want to raise the query because there is difference of dates. The memo is prepared on 22nd of February when there was no case.
Yes, Your Lordship.
Okay, they were arrested on 25th of February. That is my point.
Lordship,
So always read
actually, I just want to
papers
state that
carefully.
yesterday was our defense side. Out of this
No problem.
computation,
No
we had yesterday our defense,
Okay.
and we raised this point. But today
Make
was
it
the
a habit
prosecution
now.
side, so we were not raising because it was against our team only.
Okay.
Yes, Your Lordship.
I know, but you should be honest.
Lordship.
At
Sorry.
least give some.
If you think we were not honest.
This query has to be raised by the defense. They have
Yes,
not
Lord.
raised.
Yes, Your
Yes,
Lordship.
sir.
So, as a student, you must go all the document carefully, and if there is a problem or then you should appreciate it honestly. That is my point. Okay. Good luck.
Good luck to all.
Thank you so much, sir.
Thank you so much.
Okay. Good luck.
Thank you so much, sir.
Thank you, sir.
Thank you, Joseph. Very enlightening session. With your permission, can we conclude for today, sir?
That's all. Good day.
Have a good day, sir.
Neeraj, sir. Neeraj, sir.
Yes, sir, please. Please.
Yes,
sir.
please.
And Neeraj, can you conclude, sir? Okay, so the marking scheme just tended
We will,
to
we
be.
will
Yes,
just, we will just.
We are within 10-15 days.
We just
Minutes for it. Okay.
right. Okay. Thank you. Thank you.
I'll
Bye.
contact you.
Okay, bye.
Best of luck to both the teams.
Thank you. Okay.
Thank you, sir.
Okay, bye.